I'd like to call the order the Thursday, December 14th full board meeting. First item on the agenda is Pledge of Allegiance. Please rise. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Item number 3, roll call. Please check yourself in. Good. Thank you. Item number 4, invocation by Robert Brannon from Bethlehem Lutheran Church. This is through Commissioner Kathy Toko invited Mr. Brannon in. So, Mr. Brannon, the floor is yours.
If I could just really quickly give a little bit more of a thorough introduction of Robert. Robert is the pastor at Bethlehem Lutheran Church in Harrison Township. He is also the pastor at Triumphant Cross Church. He is the president of the Fraser Goodfellows, and he is also the treasurer of the Good Shepherd Coalition, and he's one of my dearest friends. He was a resident of Fraser. Robert?
Thank you. On behalf of Bishop Don Chris of Southeast Michigan and 116 parishes, good evening. Thank you for having me here for your invocation. Let us pray. Gracious and heavenly Lord, we give you thanks for all of these who are gathered around today, who are doing the work of the county. Lord, I ask that you be with them throughout this meeting and throughout this holiday season as we come to this time of the year and we start to light the Advent wreath that talks about hope, peace, love, and joy. Continue to be a light in a world of darkness. Lord, I ask that you be with each and every member as they make discussion here this evening and as they move the county forward. Go deep within them spiritually and be a guide in all that they do. Lord, I ask this in your heavenly name. Amen.
Amen.
Thank you, Robert.
Thank you. Item number 5, need a motion to adopt the agenda. It's moved by Commissioner Brown, supported by Commissioner Leonetti. Please vote.
Mr. Chair, if I could just make a comment as to the agenda and just voice my objection to the meeting time change and the late additions to the agenda.
It's duly noted.
Thank you.
Okay. Motion passes. Item number 6, need a motion to approve the minutes from dated November 9th, 2017, full board. Motion by Commissioner Toko, supported by Commissioner Drollet. Please vote. Motion passes. Item number 7, public participation. Any members of the public wishing to speak, please give us your name. You have 5 minutes related to agenda items. Mark.
Thank you, Mr. Chairman. Mark Brewer, resident taxpayer here in Macomb County, a practicing lawyer here as well. I'd like to address the board as to item number 9 on your agenda tonight. I am part of a group of lawyers and law firms, my law firm, as well as the law firm of Summer Schwartz, which are also involved in this litigation. And we would very much like the opportunity to make the same presentation that you're about to hear tonight, so that the taxpayers of this county can have the benefit of competition between the proposals, and you can determine ultimately the best means of representing the county in this matter. This just recently came to our attention. I saw that this was on the agenda, so I wanted to come here tonight and make this request that the board allow my law firm, the Summer Schwartz law firm, and our consortium of firms to make a similar presentation as you're going to hear on item 9 tonight. Thank you, Mr. Chairman.
Thank you. Any other members for the public wishing to speak? Any other members of the public wishing to speak? Third and final time, seeing no one, public participation is closed. Item number 8, correspondence from the Office of County Executive. We have none. Item number 9, presentation from regarding the civil litigation with the opioid and narcotics distributors. We have Mark Bernstein here from the Sam Bernstein Law Firm, and I believe Paul Novak from Weitz and Luxenberg.
Thank you, Mr. Chair. Thank you, Commissioners. We appreciate your time.
Welcome.
We will be...
can I start, Mark, with can I get a motion to receive and file, then we can move on from there. Motion by Commissioner Brown, supported by Commissioner Lucido. Please vote on this, and then we'll give you time to speak on this.
Mr. Chair, what are we voting on?
Motion to receive and file.
The presentation?
Correct. we're motion to, just to receive and file, but then now they can speak on it. That's fine. Well, usually it's different because it's Christmas. So, gentlemen, the floor is yours. Motion passes.
Thank you. We appreciate it. So again, thank you for having us. Paul is with the firm of Weitz, Luxenberg. I will do him no service introducing him. We'll get to him in a second. But we are working together, our firms, on this fast emerging opioid litigation, civil litigation related to counties and municipalities who are working to get taxpayer money back that they have expended related to their costs dealing with the opioid crisis. Paul will get into the specific lists of damages, but they broadly fall into two categories. One is law enforcement, and the second is generally community health related expenditures. We have been engaged in this litigation for months now, speaking to municipalities, cities, and counties primarily about what this means. This is a case that has obviously enormous societal value, personal value for many people in every community that we're talking to. And then, of course, at the county level, economic implications that are enormous. So we have already been retained by the City of Detroit, the City of Lansing, Delta County in the Upper Peninsula, Grand Traverse County, Genesee County, Saginaw County, Leelanau County just a few days ago. Manistee County has voted to retain us, and so too has Benzie County. We spent the week last week, or not last, it feels like it was last week. We took the red eye in from Traverse City this morning. A flight that was supposed to leave at 5:15 p.m. left at 5:15 a.m. today. So if we're a little incoherent, that may be the reason, one of the reasons, but not the exclusive one. In many respects, this is a case that is similar to, but not identical to, the tobacco litigation that unfolded about 25 years ago. That was a litigation that resulted in about $3 billion being recovered for the state of Michigan. It never really got down to the county level for a number of reasons, all of which, though, indicate that counties do need to take matters into their own hands with respect to this litigation if they hope to see any recovery in this matter. We believe that counties have a fiduciary responsibility to their taxpayers to proceed with this case for the financial reasons. But there are also enormously important injunctive pieces of this litigation that will be included in this. In other words, not just financial demands made by this county and other counties, but injunctive relief sought. In other words, demands that these opioid manufacturers and opioid companies that distribute these products change their conduct, change the behavior that is causing a flood of these medicines to be on the market. This is litigation that let me just end by talking about what this case is not. This is not a personal injury case. It is not a case for pain and suffering for a particular specific individual plaintiff. This is a case for economic damages incurred by counties that are forced to clean up the mess that's been caused by these opioid manufacturers and the distribution companies. It is also not a class action case. So it is not a case where your claim gets merged into hundreds or tens of thousands of cases with one law firm representing the class, and everybody gets like a little gift certificate to Starbucks at the end of the case. This is a mass what we call a multi-district litigation that is rapidly unfolding, where the county would file a claim in the Eastern District of Michigan in the federal courts. That claim is independent and autonomous in many respects from all the other claims that are filed in this matter. Just about 2 weeks ago, today actually, in St. Louis, the U.S. Supreme Court Judicial Panel on Multi-District Litigation, a panel of judges that are impaneled by the U.S. Supreme Court, heard motions to establish a multi-district litigation. Within about a week of that period of time, that panel established a multi-district litigation, assigned the multi-district litigation to the Northern District of Ohio, to a federal judge in Cleveland. And what will happen is all of the cases that have been filed, and there have been about 100 cases so far, and every case that's filed, that will be filed, are tagged and essentially removed and placed into this particular judge's courtroom. And then, in that instance, those cases they proceed not as a class, but they share an economy of scale. So instead of taking a deposition 600 times, we believe there will be, right now there's about 100 plaintiffs in this case, 100 municipalities. We expect this to be between 500 and 2,000 municipalities. And we can go into the reasons behind that. But instead of deposing the CEO of McKesson Drug Distribution Company 1,000 times, that person is deposed once or twice. There are enormous benefits from this, an economy of scale that is quite important. And Paul and our firm have been involved intensely in these multi-district litigations in the past. But what's very important and is relevant with respect to timing of this is that after a multi-district litigation is established by the court, which has happened, the next step is a plaintiff steering committee is established by the court. And the plaintiff steering committee is a collection of a handful of law firms that represent all of the plaintiffs in procedural matters. It is essential, we believe, from a number of unique reasons to Michigan, that Macomb County have representation on that plaintiff steering committee. That plaintiff steering committee will likely be identified in the next, I would say, roughly month or so. And so that creates a very important time issue that I think needs to be considered. If you're not on the plaintiff steering committee, you don't have a great deal of control over the process involved in the litigation. So that informs, I think, some of the pace and timing that we're confronting right now. The last thing I want to say is that this is not a case where we are trying to eliminate these medicines. These are important drugs that do important things for patients who are in horrible pain. They give great relief for people who need that type of relief. But they're really only supposed to be prescribed in 3 very narrow categories. One is in unique cancer-type oncological treatments. The second is palliative care, end-of-life care, where the interest is pain management and addiction is not as significant of a concern. And the third is in inpatient or immediately post-discharge circumstances from a hospital. Those are the 3 instances. They shouldn't be prescribed for a root canal. And Paul will likely get into the addictive qualities of these drugs and why that is the case. But I'm just honored that you gave us the time to talk to you about this today. We're thrilled at the possibility of working together on this case, and I'll turn it over to Paul to continue with the presentation.
Mark, I'm sorry. Can you give a little bit of the history of how we got to this point? I mean,
Sure.
I've talked to a lot of the commissioners about, your meeting early on with the executive and the attorney and myself, and that this has been going on even behind the scenes for quite some time.
Yeah, we've been at this way before snow got on the ground. This past summer, towards the end of the summer, this is in a litigation that began to pick up steam, and we've been involved in it for many, many months now. It's a case that fits very squarely within the core competence of our law firm, a firm that's done a great deal of pharmaceutical work and medical device-related work. It's not identical to that, but it's similar. We work with Paul's firm, Weitz Luxenberg, that's located in Michigan, or has an important office in Michigan, for years and years and years on cases that are similar to this. And so people began to reach out to us, and we began to have conversations about what this means for municipalities. Oakland and Wayne filed a lawsuit sometime in September, and that gave some traction and more attention to this. And we've been at it since that time, but reached out to municipal leadership here who, and I live in Washtenaw County, and Washtenaw County just passed a millage. Half of it is going towards opioid-related costs. And so the opportunity for counties to, obtain injunctive relief that can protect citizens of the county and also have an economic recovery is enormously appealing. But we also know in these cases that you have to move. It's emergent. It moves rather quickly. And especially in a multi-district litigation, it's important to strategically obtain a place where you can have an influence on both the process and the substantive elements of the claim. So we've been working with we hope the people in Macomb County, that municipal leadership that can help guide us and guide the county in the right direction on this. And I hope that's addressing your question.
That's
Mr.
fine,
Chair?
thanks. We'll
Yeah.
talk more about it later.
Sure.
but
Okay.
Paul?
Thanks, and thanks to all the commissioners for giving us the opportunity to present this evening. My name's Paul Novak. I'm with Weitz and Luxenberg. It's a national law firm based in Manhattan. I am not a New York lawyer. I run the Detroit office of Weitz and Lux. I grew up in Michigan. I practiced for 16 years in the Michigan Attorney General's office for Frank Kelly, and then Jennifer Granholm, and then Mike Cox. And a number of cases that I litigated on behalf of the state were pharmaceutical cases. In a slightly different context, they were antitrust cases, where pharmaceutical companies engaged in price fixing or pay-to-delay deals, and we would bring antitrust actions. In some of those, I had the opportunity to represent not only Michigan, but all 50 states in a coordinated case where we were lead counsel, and I was lead counsel for all 50 attorneys general in addressing illegal distribution practices of pharmaceutical companies in that context. Since leaving the Attorney General's office, I've spent a number of years now litigating pharmaceutical cases in private practice. And the firm that I am involved with, Weitz and Luxenberg, is a leader, I think, in the national litigation, particularly in drug and device cases. Paul Pennock chairs the pharmaceutical group. He's based in Manhattan. He is frequently, in those instances where our firm becomes involved in these types of cases, either appointed to the plaintiff steering committee, the kind of umbrella plaintiff organization that controls, in the instance of these multi-thousand case kind of conglomerations, the manner in which those cases are litigated. And if he isn't actually chair or on the plaintiff steering committee, he's in some instances actually the chair of it. And I think that speaks to not only the courts and their respect for his practice, but also the respect of the fellow counsel who practice in that area. You typically don't become involved or appointed to the plaintiff steering committee, which is a judicial appointment, without the court making a determination that you're well qualified to serve in that stead. And even more so if you happen to chair plaintiff's litigation or a plaintiff steering committee. Let me talk for a moment about the national epidemic that opioids have become over the last 2 decades. And I won't belabor this point because I think at this point it's on everyone's radar screen. President Trump recognized that it is a national emergency. Clearly the state of Michigan has recognized in the last few years that it has become an epidemic. And every time I look at these numbers, they increase. The estimate that it might even be in our presentation of $78 billion a year is the social and economic costs in terms of lost productivity, lost wages, incarceration costs, all of the different costs attributable to the addiction to opiates. That number is outdated. It has since ballooned, and the most frequent or the most recent estimate that I have seen of the annual costs of this epidemic are that it is in excess of $500 billion. And a large portion of those types of costs are costs incurred by government. And they're incurred particularly in Macomb County. There are costs associated with, and I'll just run down a few categories of the things that the taxpayers of Macomb County have had to pay as a result of this epidemic. In each of your county sheriff's cars, there is going to be a Narcan or a naloxone, which is an opiate overdose treatment that allows a sheriff to intervene if they confront someone who's in an overdose situation to hopefully save their life. Those are typically $600 or $800 a pop, and you've got them, I believe, in every county sheriff's car in this county. your emergency treatment costs, when you have to make runs for any kind of opiate overdose, the incarceration costs and the medical costs associated with that. We were talking with folks in Genesee County, and the sheriff there estimated that 50% of the inmates just in the Genesee County jail had opiates in their system. So they have to administer, as part of the medical costs for those inmates, detox, and there are costs associated with that, and the medical costs associated with attempting to take the individual out of an addicted state. There are costs, substance abuse treatment and mental health counseling costs that have exploded statewide and here in Macomb that are attributable to this epidemic. When we were talking to one county the other day, they said, look, we've got a coroner's contract with the local hospital. And we had such an unanticipated increase in the number of, unfortunately, overdose deaths that have occurred in our county. We had to relet the contract and increase the funding for it because we have to perform so many more autopsies to make a determination of what the cause of death was. The prosecutors who prosecute cases involving opiates have to run, in many instances, blood work and then have that blood work analyzed by an out-of-state laboratory, and if they're going to actually prosecute the case to trial, bring in an expert witness to testify regarding and to admit into evidence the laboratory analysis that establishes the opiate levels in the blood of the person who is under prosecution. Those are just some of the examples that we confront when we talk to counties. I'm sure that if we sat down with some of the respective folks in your counties, every time we sit down with different counties and start talking with the relevant stakeholders within county government, we come up, it seems like, with a new category of how the taxpayer has increased or confronted greater expenses as a result of this epidemic. If I may for a moment, I want to talk, though, about the nature of the epidemic here in Macomb County. I don't know if the PowerPoint's up. Statewide, there are approximately 1.07 prescriptions for every man, woman, and child that are living in the state of Michigan. It's actually a higher rate of prescribing activity here in Macomb County. It works out to roughly 1.1864 prescriptions for every man, woman, and child in Macomb County. There is an enormous amount of prescribing activity going on here in Macomb. You can see the type of increase we've had just since 2009 is 38%. The number of deaths, fatal deaths attributable to both heroin and opioid overdoses here in Macomb County, you're ranked number 2 for all of the counties in Michigan. 50 deaths in 2014, 86 deaths in 2015, and 202 in 2016. This is not a trend that should be taken lightly, and obviously all of you appreciate that. These are figures that we're seeing across the state, and they certainly are significant here in Macomb County. The deputies, and I've already talked about the number of instances where they have to respond to an overdose treatment situation and administer naloxone, hopefully in order to address an overdose before it becomes fatal. Sometimes that's a successful endeavor, and sometimes it's not. Macomb County had the highest rate of doctor shopping. This is part of the illegal diversion conduct that occurs. Individuals will make presentations to different physicians in an attempt to get as many prescriptions as possible. The MAPS system that the state of Michigan has implemented is starting to address that type of diversion, but there are many other instances of diversion. And Macomb County, unfortunately, is seeing a significant amount of that that's occurring here in the county. And then if you look at the number of deaths that are occurring here in Macomb, The opioid deaths that are occurring in this county are greater than the number of deaths that you're seeing from guns and traffic fatalities combined. It is a significant issue here. I noted in some of those statistics we talked about both opiates and heroin, and the reason we do that is because 80% of people who are chemically addicted to heroin started on a prescription medication. The most chilling statistic that I think I've confronted when looking at this epidemic is that of those individuals who have taken a prescription opiate product for only 8 straight days, 13% of those individuals will still be on some type of opiate product a year later. That shows you how powerfully chemically addictive these drugs are, and that leads me to what the bases of the lawsuits are. The first basis is that the deceptive conduct engaged in by the manufacturers, misbranding this drug. Purdue Pharma, one of the largest pharmaceutical manufacturers of OxyContin, pled guilty to misbranding and minimizing deceptively the addictive qualities of OxyContin in 2007, paid a significant criminal fine. Some of the other manufacturers have also contributed to a deceptive effort to mislead physicians about the true addictive extent of these drugs. And part of what this lawsuit would be designed to address, if we were retained by Macomb County, will be the deceptive conduct engaged in by manufacturers. The second area or prong of conduct that would be at issue in litigation involves distributional issues. In addition to the manufacturers who may be going to different physicians' offices, and in some instances they know that there are particular physicians. We had a physician, I think, in Warren, who was criminally prosecuted, who averaged 47 prescriptions a day that he was writing for opiates. And there are others in this area who have been criminally prosecuted. The pharmaceutical manufacturers know, and in some instances encourage, that rate of prescribing conduct. But what they should be doing, and what there is a statutory duty, both for the manufacturers and for wholesale distributors and large retailers, they have a statutory obligation under federal law when there is a suspicious amount of either prescribing conduct or a suspicious amount of distribution conduct. Say a particular wholesale warehouse that has drugs sufficient to cover a population of 1 million, but that warehouse is only distributing to a number of pharmacies that support a population of 50,000. You know, in that instance, that there is diversion, illegal diversion conduct. And there have been, in the books that we passed out, at pages 31 and 32, a summary of the criminal and civil fines paid by those different wholesalers and manufacturers involved in some instances with addressing their distribution conduct in the past. So we've got deceptive conduct as it relates to the addictiveness of the drugs, and we have a failure to report the instances where illegal distribution and diversion of these drugs is ongoing, where the manufacturers, the wholesalers, the retailers take a blind eye because they're profiting from the conduct that's ongoing. Those are the areas that the lawsuit is intended to address. What it would be intended to do is to capture from these different defendants the costs that the county has incurred and will incur. It also will seek injunctive relief. The funding of some of the county's programs on a going forward basis to address this crisis. Modifications in the distribution practices and the marketing practices. Those are the types of things that the lawsuit is designed to address. And the important thing, and the reason why we are before you tonight, is that we anticipate, perhaps as early as within the week, that we will be submitting, after filing litigation, on behalf of a number of different counties and cities. And Mark listed many of those, but not all of them. We anticipate submitting an application to be on the Plaintiff Steering Committee, part of what will become the committee that guides this litigation, not only for Macomb County or Detroit or the other counties that we referenced this evening, but guide it nationally. And we think that having Macomb as part of that application will give it more heft, because you are certainly, unfortunately, as the statistics bear out, one of the most afflicted counties in the state. By the way, there are some counties who have it much worse on a per capita basis. There are a few northern counties that we've visited in the last couple days where the numbers are even the prescribing conduct and the per capita conduct. They certainly don't have the population that Macomb does, but the prescribing conduct is even worse than it is here. But it's, in terms of the national average, Macomb is far above that, both in terms of the number of deaths on a proportionate basis, the number of prescribing conduct on a proportionate basis. And we hope you'll consider our application to be retained.
Thank you. I have a couple commissioners here with questions. Sure. I think I might want to ask our corporation counsel to come up just for a minute and kind of give the so Monday was a little bit skewed. This was there was a motion on to talk about these gentlemen on Monday. I'll take a little bit of the responsibility for not being prepared nor preparing everybody for that. But can you just explain, John, like what they've spoke to you about before and how this whole process works when it comes down to eventually hiring attorneys, outside attorneys? Because I know we don't pick the attorney. That comes right from corporation counsel, just like anything.
That's correct. Historically, the county of Macomb used a lot of outside counsel up until perhaps 4 years ago. And with my taking the role of corporation counsel, we've cut down on the use of outside counsel tremendously. It's actually fairly rare at this point. Nonetheless, under the county charter, which is very clear, any request for retention of outside counsel must originate with my office. Under section 7.5.3, corporation counsel may appoint special outside counsel with the caveat that that request must be approved by the Board of Commissioners. It's strictly something that is exclusive within the authority of the Corporation Council with the Board of Commissioners' permission. And we have never in my experience have we ever sent out RFPs for outside counsel. These are personal service contracts which do not require RFPs. And historically, at least in my term as Corporation Counsel, I simply look for skills and experience to match the unique challenges of a given piece of litigation.
Okay, thank you, John.
Now, that's what we've done in this case.
Thanks. And if any other questions are for John, feel free to ask. But Commissioner Brown, you're first up on the list.
Thank you, gentlemen, for coming in. It's definitely a crisis. Is an epidemic, and you outlined the facts very clearly. But explain again how there's been laws been broken by the distributors disseminating so many, maybe out of proportion, number of drugs to a particular doctor or clinic, perhaps. I mean, is that an illegal act? And if it is an illegal act, how come we aren't using our state's attorney generals and others to prosecute them, and there'd be no need for a lawsuit? Let the law work.
Yeah.
Can you speak to that?
Sure. First of all, there have been some criminal prosecutions. I can think of 3 just in the Macomb, Wayne, Oakland cluster within the last 2 years of physicians who were federally prosecuted for overprescribing. The one case that I identified of the guy who was writing 47 scripts a day, he was criminally prosecuted. So there certainly is some amount of that activity. And the summary of some of the settlements that were presented in your booklets at 31 and 32, some of those are instances, well, the Purdue Pharma was a criminal plea for misrepresenting the addictiveness of OxyContin and misbranding associated with that. They pled guilty and paid a criminal fine. In other instances, they've been civil resolutions rather than criminal resolutions, but identifying situations where the Department of Justice or the FDA has pointed to certain distributors and said, you have failed to report suspicious activity where you should have, and had them enter into civil agreements that paid civil fines. That hasn't come anywhere near addressing the magnitude of the problem. The United States is 4% of the world's population. We consume 81% of the world's opiates. So we have a long way to go in terms of reducing the scope of activity that occurs in this country as it relates to opiate consumption.
Thank you, Mr. Chairman. Thank you.
Commissioner Drollet.
Thank you, Mr. Chair. Thank both of you for your presentation. I just need a couple clarification. Are we suing the manufacturers and the distributors, or just the distributors, also the manufacturers?
We would propose to sue both the manufacturers and the distributors.
Okay, that's a little different than was represented to us the other day. How much would we be suing them for?
Well, after the suit is filed, we will sit down with county representatives and start to assemble a damages model that takes all of the different costs that I've talked about, the categories of costs that I have spoken about, and start to place those into a damages model that we would present. I can't tell you what that number is today. I gave you examples of the types of costs that the taxpayer has had to foot that would be in that, the naloxone payments, for example, any detox treatments for inmates who are in the county jail. Those are the types of categories. I can't tell you what that amount is for the county, but I expect it to be significant.
Okay.
So, Commissioner Drell, just to add, in the aggregate, not for one particular municipality, but the state recovered $3 billion in the tobacco litigation. Mm-hmm. It hocked the money, and it's a long, you probably are familiar with that, and counties didn't get any of it, really. I mean, very, very small amounts. But we believe that this case is, it's not identical to that case at all, but there are similar scope and scale to this that I think most of the legal community appreciates right now.
Okay. If indeed the distributors are distributing to doctors that write prescriptions, why aren't we suing the doctors that write the prescriptions? I mean, the distributor just has to trust that a doctor has written a prescription to somebody for a healthcare product, and they're not the doctor, the distributor. Why aren't we suing the doctors?
As I identified, in some instances, overprescribing physicians are being criminally prosecuted. One of the reasons that makes it awkward to bring physicians in any particular community into this national multi-district litigation in Cleveland is that if litigation were to be pursued against physicians, it might be more appropriately handled in the different places around the country where those physicians sit. But more importantly, the suit is designed to address the deceptive conduct that has misled physicians about the addictive qualities of these drugs.
So physicians don't realize that it's addictive?
They certainly are becoming aware of that, but we now have people who are addicted to these products during an era of prescribing where, for example, Purdue specifically engaged in mislabeling that would have suggested a far less degree of addictiveness about these drugs.
It seems
than
curious that the
now.
average person knows that opioids are addictive, but that doctors didn't know that.
Well, it's an awareness that has become, that has grown actually quite recently. And these manufacturers and distribution companies engaged in not just not just mildly deceptive marketing or generally, but produced videos that said that these weren't addictive, or had literature created that said if you had a patient that wasn't asking for opioids, they were actually being stoic and they actually needed more. The conduct of the manufacturers and the distribution companies in this that has been revealed through discovery, in some instances through attorney general cases, but in other instances, is remarkable. It's astonishing in terms of the deception that they prosecuted with respect to the medical providers, and that's been part of the ongoing. That's been revealed, and fines have been paid. I mean, not just small fines. Purdue has paid hundreds of millions of dollars.
You provided us a nice list of some of the settlements that have been obtained.
Yeah.
And I'm curious, like, for example, Cardinal Health in 2008, there was a settlement with 8 states for $34 million. Do you know how much they sued for and what they ended up with? I know they ended up with $34 million, but what was it they asked for? Similarly, there was 7 states that sued McKesson Corporation and received $13.25 million split with those states. And I don't know what they asked for, but what they became now with the Purdue Pharma, obviously the largest settlement at $634.5 million, and that would dealt specifically with the state of Virginia primarily. So how much did the state of Virginia's opioid addiction rates decline after that settlement was put into? Have the states that have settled these things saw reasonable declines in the opioid problems? Because a lot of the states listed here with those settlements in 2008 show up on your map of states with severe opioid problems. Yeah. They didn't fix those problems, or at least help?
I would submit that this is so profitable that in many instances these defendants have paid the fines and just keep going. And we've seen that in a few instances, actually.
One example of that is one of the wholesalers on our list. I think you pointed to the $34 million civil penalty or civil settlement that they had in 2008, I believe. They had a repeat. They paid an additional amount of $150 million just in early 2017. So the $34 million clearly wasn't a figure large enough to suggest to them that they should significantly amend their practices.
Yeah.
Whether the $150 million that they paid was, we'll see if that has an impact on their practices. But we've shown what the level of the epidemic is, and until there is, I think, a proportionate response that tells companies that it will not be profitable for me to continue with this type of practice, they may find it more profitable to simply pay the fine and keep on going.
Yeah, I guess it's hard to gauge what the outcome of a lawsuit is going to be, obviously. But, you look at the $34 million settlement with 7 or 8 different states, you take out the third that the attorneys get, and then you split the remaining 20-some million with 7 states. It doesn't add up to all that much to reimburse those communities for the damage that these opioids have done. Similarly with the Cardinal Healthcare, whether the McKesson one, there's 5 or 6 states involved, $13.25 million. Take out the attorney fees, split it 6 ways. Everybody gets $1 million, and the opioid epidemic continues according to the graphs that's shown on one of your other pages, the 2013 graph.
I think
so we get very little money, and we don't end up solving the problem.
A number of those states are continuing as part of the National Association of Attorneys General investigation. So I don't think even the states that you pointed to are done. A number of them are participating in.
Has there any case where a state has been able to reduce the opioid epidemic through successful lawsuits?
I don't think the amount of monies that have been paid to date have successfully reduced the amount of the epidemic. As I said, even with those amounts being paid, it continues to be profitable for
Right.
them to continue with their practices.
Ultimately, how many municipalities and states are likely to be part of this, I don't know if you call it a combined lawsuit, is that accurate?
A mass action.
Mass action, or, okay. What, if we filed next week, how many people would be included? And how many other states might be included? Is this just Michigan, or what's the scope?
I'm just guesstimating.
Okay.
And I think there will be additional suits filed even beyond next week.
Okay.
The reason why I talked about next week is because
We want to be part of
steering
it.
committee,
Yeah, steering committee.
is going to be formed soon.
So how many municipalities do you guess will ultimately potentially be involved?
If I had to guess, I'd say it's gonna be over 1,000, and it could be over 2,000 or 5,000 different local governments. that are
Okay, so we could potentially be splitting a settlement 5,000 ways after we pay a third to the attorneys.
The settlement that Macomb County negotiates will be negotiated by Macomb County. It won't be, and this is a distinction between a class action case
Okay,
and a mass action case. A class case, and I've been involved in some of those, there is one settlement negotiated for the entire class, and it's distributed in the manner that you suggested. A mass action is one where all of the individual litigants will individually negotiate the amount that they obtain.
do we have to then, if that's the case where we're negotiating an amount specifically for Macomb County, do we have to demonstrate that the distributors and manufacturers' actions occurred in Macomb County? That the distributors were the bad actors in Macomb County, they were distributing, poorly in Macomb? Are our recovery based on the damage that we can prove they did in Macomb specifically?
Now you're going into causation questions that, frankly, as a matter of litigation strategy, I'd prefer to discuss in closed session than open session.
Okay.
But let me just say
Generally
that-
with these types of cases,
that what we will need to demonstrate is that in some manner or another, the conduct, irrespective of where it occurred, has contributed to the issue here in Macomb.
okay. That's all I have. Thank you very much for being here and for answering the questions. And thank you, Mr. Chair.
Thank you, Commissioner. Commissioner Romano.
Thank you, Chair. Thanks, gentlemen, for showing up. I tread on very thin water when I say this. I'm not as sympathetic as everybody else is about this opioid thing. Having said that, and I think Commissioner Drollet came up with a heck of a statement. He said, why don't we sue the doctors? And why stop there? Why don't we, and it's rhetorical, why not sue the pharmacists? Why not sue the hospitals that distribute it? Why are we just picking on the drug manufacturers? Let's sue the automobile companies for having cars that go 140 miles an hour when our speed limit is 70 miles an hour. Why the drug companies? You say they're misled. Who do they mislead and for how long? I think all of us have had prescription pain medications. We have people right here on this council that have taken them, or probably taking them right now for the simple operations they've had. All of them contain, myself included, all of those contain, please understand these may be addictive, and it states right on the label. So when you come off with say, well, the pharmaceutical company's misled, I mean, it's there. The doctors aren't stupid. They know if these things, and you mentioned these doctors that overdosed some, or came up with all this plethora of prescriptions. Those are criminals. We're not talking about medical doctors. Those are criminals that intentionally put these prescriptions out for a fee for every prescription that they wrote. So you can't categorize them as the doctors are sending out too many opioids. What happens to the point that we get that these people that are in pain, that do need these, the doctors are going to be scared in their pants that they're going to write these prescriptions out? I think this thing is going way overboard. My own personal opinion. I hear Sheriff Wickersham here, I read in your report, he says that they have one or two every time they're on the road that somebody overdoses here in Macomb County. Thank goodness for Narcan. At $600 a pop, is that what you said? $600 a pop? All right, $600 a pop. It says we've saved already 35. What's the rate of recidivism for these 35? Are they back on again next week? What are we doing, chasing our tails? I mean, this lawsuit is great. We're going to get a piece, but again, piggybacking on Mr. Drolet's, and everybody's entitled to their fees. You guys are going to work hard for this. Are you entitled to each individual county or municipality that you collect for, or is this a grand total? And I don't want to get into your fees. Is this a grand total that you collect in one lump sum, or does it depend on the municipality and how much you collect for them? I'm throwing out a whole bunch of stuff at you, gentlemen. The commission here knows my idea is build more jails. but
Most of it's rhetorical.
Answering a rhetorical question is dangerous terrain. Right,
Okay.
But if I may, one of the things that I think that is important, I believe, in this instance, is I think counties are looking at this and saying, what can we do here, right? There is a role and an acknowledgement regarding personal responsibility in this. That's important to acknowledge, and I think Commissioner Drillette is addressing. I think you're touching that as well. But at the end of the day, the county gets the bill. At the end of the day, the county has to save people who are having an overdose. At the end of the day, the county has to run addiction programs. At the end of the day, inmates in your jail are going to need addiction services and medical care related to this that the state isn't paying because they're in your jail. The question is, what can counties do, or what can counties, or what should counties do? And I think the answer, my sense is, the answer is everything. Every tool that you have available should be used and marshaled in this. Both the criminal justice system, and that's why the attorneys general are involved in this. That's why the DEA has assessed fines. That's why the DOJ has been engaged in this. But it's also why counties and cities across the country are engaging in this litigation, both to get their money back, but also injunctive relief that is absolutely essential to begin to bend this crisis, this epidemic. But it does begin with the manufacturers, and it does primarily begin also with the distribution companies. They're the ones that are pouring the pollution into the river, if you will. And it just goes downstream, and it all just pools right in this room where you get stuck with the bill.
Thank you, Chair. Thank you, gentlemen.
Commissioner Leonetti.
Thank you, Mr. Chairman. I guess I'll start. I'm going to have two questions. I'm going to start with you guys, and then I'm going to have a question for John over there. I know he's don't leave. So I want to talk a little bit about the centralization, so I understand it a little bit. Anybody who's out there that's bringing an action on behalf of a municipality, a county, or a state, there's multiple attorneys doing it, multiple firms doing it, are all going to be centralized into this one court now, right? That order went into effect December 5th, just a couple days ago. Is that correct? Correct. Okay. And I know you can't speak for them, but I know the gentleman behind you indicated, at least in an open participation, that they too have a lawsuit, potentially, I don't know, but maybe on behalf of some other governmental entities. Would they too then be obviously put into that centralized lawsuit, correct?
If it's a suit that is either filed in federal court or removed to federal court, then it would be transferred over under a conditional transfer order pursuant to the centralization order.
All right. So assuming it is, then they too would end up in the same court in it looks like Northern Ohio, right?
Yes.
Okay. So then the next question is, you talk about the steering committee and the importance of getting on that committee. How many attorneys with all these 2,000, maybe 3,000 different entities suing, and I'm going to assume there's probably 100 law firms representing at least 10 each, maybe, or 20 each. How many people or how many firms get on the steering committee?
I've seen steering committees that are as small. I was appointed to one by a MDL federal district judge in an entirely different matter yesterday. There are only 3 members on that steering committee. For a case like this, my guess would be more to the 10 or 15 range.
And then I know you touched upon it a little bit, but tell me why it is you can distinguish yourself from somebody else, or why it is you feel that you gentlemen are going to have a good shot at getting on that steering committee. I understand why it's a good idea to be on it. I completely understand that. But tell me what's good about you guys. Distinguish yourselves from some of the other people that you know are going to try to be on there.
I'll pitch my colleagues in New York at this point. That's kind of the entree for that question. Paul Pennock and Ellen Relkin are the 2 counsel who I think are the most
Sir, would you use the microphone?
Okay.
Thank you.
The 2 counsel who are the most senior at the firm in terms of their participation on plaintiff steering committees in pharmaceutical cases specifically. Paul was, I believe, the chair of the Actos plaintiff steering committee when that litigation was waged several years ago. It was a significant piece of litigation. I think ultimately was settled in, the aggregate amount of the settlements were in excess of $1 billion. Ellen Relkin has been appointed on multiple occasions in both drug and device cases. to different plaintiff steering committees. I kind of come at it from a different perspective. My participation in these cases in the past hasn't been as a steering committee member. It's been as either leading a multi-state group of assistant attorneys general or chairing or participating in a group. I used to be part of the National Association of Attorney General Prescription Drug Pricing Task Force. And was involved in the issues from that vantage point. Okay, so the claim to fame would be experience with the two yes. folks that you're talking about out of your New York office. Undoubtedly. Okay, all right, thank you. John, I have a question for you, and it relates to the county charter. If I'm to understand the county charter, the function of the board would be for us to say, yes, we approve pursuing this type of litigation. We want you guys down there, Corporation Counsel, to do this, all right? And if we approve the litigation, we, if I understand the charter right, have no control really in who you pick. I mean, you could bring a bunch of different attorneys to us, and we just have to approve a particular firm to do that. Is that correct? You have the choice on who you bring in front of us to pick for the litigation. Is that correct? Subject to our approval.
You sort of changed up the question midway through.
Well, yeah, sorry, I'm cross-examining you, right?
No. It started out, I thought, well, you got it backwards. Now you got it frontwards.
Yeah.
No, the board has no real play, no approval in the litigation. The board's approval power is limited to approving my request for the retention of outside counsel.
Okay.
That is a straight up and down vote. If it's no, I either go back and look for other counsel, or if we're on the offense, I abandon the action at that point.
Okay.
But the board's role is limited to approving my recommendation, and I make the recommendation.
Okay. Have you thought about a recommendation on this? I don't really know. I mean, we have a presentation today. Do you have a recommendation for us today?
Yes. I appeared Monday to make the recommendation.
I wasn't here, so I do apologize. Okay.
To retain the Bernstein and the Weitz Luxenberg law firm for this specific purpose.
Did you consult with any other firms or look into any other firms?
No.
None at all?
And I ordinarily don't when I'm choosing outside counsel.
Okay.
As I said, I look for skills, experience, and then match those to the challenges of a unique bit of litigation.
Okay. All right. Thank you, Jim. Appreciate it. Thank you, Mr. Chair.
Thank you. Commissioner Kleinfeld.
Thank you. I want to set the record straight on a couple of things, but now I'm assuming that the sale point is that Weitz and Luxembourg may have a bunch of Bernsteins in different states. Would that be accurate?
We certainly have spoken with local governments in other states, but we've actually focused here in Michigan.
Oh, this is your focus. Yes. Okay, and you're more likely that it's Weitz and Luxembourg that would be shooting for the steering committee as opposed to Bernstein. Is that correct?
Yes.
Yes.
Okay, and I don't care how anybody votes. That's not my business. But I want to set the record straight on a couple of things. First, who is addicted and who's distributing, like the doctors. All the doctors aren't crooked, because that would mean every doctor up north if you take a look at those maps. But in 2015, my husband had major surgery, and he got a bottle of pills this big with refills. In 2016, just 1 year later, as you all know, I had major surgery. I got, I think, 10 pills. And I was still in extreme pain because I wasn't through with everything that was going on, and they were reluctant to give me more. So something happened between those 2 years that changed things dramatically. So I think that we're going to see a drop because of that, not because of a change in how the distributors are acting, but because of that. We do still have the problem of the doctor shopping and of the doctors that are willing to give pain meds. So to answer your question, Commissioner Romano, yeah, it is affecting people that are having major surgery now. Everybody's afraid to give them out. However, who's addicted also, you've linked it with heroin, and there's a reason for that, but I think it puts a perception that may not be correct. my children lost a classmate who would be 25 years old today, who was a cross-country runner, who got injured, and he died of an opioid overdose. So we're losing athletes, we're losing grandparents, we're losing, it's just not your run-of-the-mill people that go down the wrong path and get into things that they shouldn't. So I just wanted to set the record straight on that part of it. And with respect to the question about whether or not you get a percentage of the pot or a percentage of each client, if you get 30% of each client or 30% of the pot of money from those clients, it's the same amount of money. There's no difference between the two of those. And whether we get $1 or we get $1 million, that's $1 more than we had yesterday. So that's all I have to say. Thank you.
Thank you, Commissioner. Commissioner Toko.
Thank you, Mr. Chair. Can you describe what the role of the two firms would be and why we would need to retain two firms in this?
So it doesn't increase the percentage cost. Our experience in doing mass tort-related actions, I'm using that very generally, but whether it be a pharmaceutical case, an asbestos case, a medical device case, has been that we believe that it's absolutely essential to have a state local presence in the case. Someone that you can, and in this instance, you get the benefit of having Weitz Luxenberg, a national player in this, an expert in this arena, incredibly accomplished, right here in the state, which is very important. Our firm is heavily involved in activities in Macomb County and just down the street. So you should have somebody that you can pick the phone up and ask what's going on. How is this case proceeding? What's happening with it? We're working on the damages together. Let's meet down in Mount Clemens and go through this. Let's sit down, and we're going to have a damages team, for example, that will be right here working together with the various stakeholders to determine, getting to your question, Commissioner Drillette, a little bit, what are the damages? Being here, being able to see each other, not doing it by phone from, an office in Washington, D.C. or San Francisco, I think is an enormous difference. We've seen that on our individual cases that we've worked with together with Paul's firm, literally on a daily basis. And we've worked together on, this isn't just a new marriage here. We've been working together for almost 2 decades on these types of cases.
So, Mr. Bernstein, would your firm be acting as a liaison between the Weitz Luxenberg, or would you actually be doing, entering your appearance
Sure.
in the case and doing the work?
Oh, sure. We would be on the caption of the case. We would be engaged in the litigation. Yeah, we're not just kind of handing this off and letting Paul go off into the litigation on his own. We would be working together with him on that. So and the answer is yes, we would be engaged in this case as co-counsel with Paul's firm.
Okay. In the early part of your presentation, you indicated that you'd been working with officials within Macomb County since the summertime. The board heard of this was last week, so we were not aware that this was in the works or that there was any discussions on this. Knowing that you've been working on it for several months, what's the current applicable time limit? So is there a time limit for Macomb County to decide yes, we're in or no, we're not? Is there a filing time limit? I mean, what is the timetable that you have going forward?
Those are good questions. So we introduced the idea a few months ago.
Mark, can I speak? I'm sorry. I'm going to answer at least the first part of that and just clarify a little bit for you, so you don't have. You're on the spot here, and I think you've done everything right as far as that goes.
I'm not saying anybody did anything wrong. I was asking him a question.
I'm going to explain their early contact with the board and with the executive's office was with me and with Mark and with John. I did mention it to quite a number of board members. I'm pretty sure it even came out in new business at one time that we had spoke. I think that the issue is we didn't hear about the pending litigation deadline coming up next week, which you're going to speak about. I would say that the Bernstein law firm was contacting with the executive's office and probably assuming that since we were part of the original meeting that we would be included in at least the timing discussion of the of this lawsuit. That's where things got separated. I just wanted to kind of explain that in public, since we're talking in public. That
muddied the waters
well,
more for me. I mean,
I was in this originally with the Bernstein law firm, with Weitz, Luxenberg, with John Shapkin, with Mark Hackle. So I would say that, at least on their behalf, they thought that we were all involved, so that they would keep contact with the executive's office, and of course then they would naturally keep us involved. That is the part where the separation of information to us, and why we were kind of caught by surprise last week when the announcement was made at the state of the county that this was basically a done deal. So so you understand, and everybody else understands kind of where things went awry, at least in the information side of things. Carry on. I didn't want to put Mark
Someone
on the
once said
spot
that when
to
you're swimming
explain
through
what was
muddy
going
water,
on.
keep your eyes open and your mouth shut. That's what I was just
Well,
doing there.
I don't want to put you guys in the middle of this, because it's not your fault.
and there's not a
our
middle of
lack
anything. I just asked a question. It's not.
Yeah.
Well, when you say we were totally uninformed of it, I just want to make
okay,
sure.
so I was uninformed. Nobody said a word to me about it, and I asked a question about it.
Yeah, no worries. So let me answer do you want to take the MDL?
Well, there's another component of it, and that is that you'll have statutes of limitation that are applicable to these claims that will go
Would you use the
back-
microphone again?
Sorry.
Thank you.
Sorry. You will have statutes of limitation applied to these claims that will go back for a period of years. And the further into the future that the lawsuit is filed, the less amount of time for your damages window you'll be able to go back. So, and that doesn't counsel that you have to file tomorrow or next week, but it is a consideration for why you would want to file earlier rather than later.
So are you in the process now of already filing for other municipalities, or?
Yeah, so it's our, I didn't mean to interrupt you, is that?
No, that's it.
So our intention is to file this in a series of waves. The first one, ideally, would be at some point next week. That is when our intention is to file. Whoever has retained us at that point, for the reasons that Paul outlined, it does a few things. One, it tolls the statute of limitations for us, so that every day that a claim isn't filed, as you know, there's you lose that gets chopped off the end, and that can be quite expensive. And secondly, the plaintiff steering committee process, which we think is quite important, is beginning imminently. And so the ability to have Macomb engaged in the case and therefore involved in participating in the plaintiff steering committee is quite important. I mean, the state of Michigan has unique challenges in this case that it and therefore needs we believe needs PSC representation. So there's statute issues, there's the PSC piece of it, and I think there's also the faster you get engaged in this, the sooner the injunctive relief can be hopefully obtained.
Okay. That's all I have for now. Thank you.
Thank you. Commissioner Duge.
Thank you, Mr. Chairman. Thank you, gentlemen, one and all, for being here. There's a number of very interesting and pertinent comments going on here. Basically, Cardinal Health, that they got $34 million settlement. So the attorneys got $10 million, and then the 7 states had to split up $24 million, basically, because you guys get your 30% off the top.
The attorneys involved in that case did.
Or the attorneys involved, not you, but the attorneys involved in this case.
That may have been a case that was litigated by attorneys general rather than...
Fair enough. And I actually agree with Commissioner Kleinfeld that hospitals and so on and so forth are being very, very careful about what they prescribe to whom and when. And sometimes it'd probably be a better move to give them something than to let them lie there and want to die. But my question goes, that's all fine and dandy for the prescription pain pills and so on and so forth. My question is, are we doing anything about the heroin? One. And two, what does this do as far as the fentanyl supply? Because what's killing people is the fentanyl and the heroin. It's fine and dandy if somebody's codeine, Vicodin, Oxycontin, so on and so forth. Morphine, I have no idea where you'd go to get that other than a hospital. But fentanyl, I have no idea where, but that's killing people. What does this, all of this, do to address that problem?
One of the statistics I shared earlier is that 80% of the individuals who go on to other opiate products in the illegal diversion markets, whether it be heroin or whether it be fentanyl or those types of products in the illegal markets, started by becoming addicted to a prescription painkiller. And I think that the more we focus on that initial trend, the high school cross-country runner who gets injured and has a prescription that then leads to a desperate need after that prescription runs out to get it in an illegal market. If you can address that early stage of addiction, it has the potential of reducing the later stages in the illegal markets.
Well, that's fair enough, and I understand you going after that, and I'm not going to, I don't think I'm going to stand in the way of that. Nothing ventured, nothing gained. But I'd really like to see an effort put into both the heroin and fentanyl. Heroin's been illegal since God only knows when. Fentanyl, I don't know if it's illegal or not. Either way. But I'd like to see some of this focus on the heroin and the fentanyl business. Because that's what's, you know, okay, people are starting on the prescription drugs and so on and so forth. Well, what's killing them is the heroin and the fentanyl. And I'd like to see some sort of avenue to address that.
Well, the injunctive relief piece is essential in that regard, number one. Paul and I were, it was yesterday, when we were in a county in northern Michigan, when we met with we spent some time talking to a prosecutor there who started as an assistant prosecutor in this county and in 2005 approximately, and heroin was not on the radar really at that point in time.
In that county, if a sheriff's office ran into a bag of heroin in somebody's car, they wouldn't know what it was.
Yeah, and then this assistant prosecutor is deployed in the military, comes back 2, 3, 4 years later, and he said heroin was everywhere. It was as if someone flipped a switch. And we believe that that is related to opioids, based on the data that, you know, just one slice of data that Paul just shared.
Well,
Well, and to further the discussion that we had with the prosecutor, what he said was a number of the instances that he's seen, the kids that he's prosecuting for breaking and entering,
right,
is that they have started by being addicted to a prescription opiate product, and then after that prescription runs out, they try to get a prescription opiate product, basically the same product, by kids who are selling it on the street. You know, you take some out of your grandmother's medicine cabinet or somewhere else and you sell them for X number of dollars a pill, but that was still too expensive. And the cheaper form of treating or of them meeting their same addiction at that point, because they were chemically addicted at that point, was by buying heroin because it was cheaper. He ran through the numbers. It was cheaper at that point for him to buy heroin and get a number of hits off of the same bag than it was to pay on the illegal market by people who were just selling pills
for
on
the
street
pills.
For the prescription drugs.
Well, I'm linking this with our discussions with county coroner Dr. Spitz, and he's been screaming about this for the last couple of years, and the numbers just keep going up. And, well, that's my position on it. Thank you, Mr. Chair.
Thank you, Commissioner Duge. I have a few comments, seeing no other speakers on here. Commissioner, what's this? I'm sorry. Okay. Well, yeah, I'll go, yeah. Commissioner Duge, I don't claim to be any expert on this. I do sit on the advisory board for FAN, who was very big with the narcotics, and everything I've heard consistently from them is that the gateway drug to heroin and the deaths with fentanyl are start, you know, a majority of the time, and I can't, you know, they can't say all the time, with a prescription opioid problem, and that's exactly what he said. How they still need the pills afterwards, and the price is, you know, they go with where the price is for the same type of high. So I think by looking at doing something like this, we are looking at the heroin and fentanyl problem all at the same time. I just wanted to, well, whatever. Commissioner Kleinfeld.
Thank you, Chair. I indicated at the first meeting that I really wanted our attorneys to have a shot at being on that steering committee. And they've indicated that having Macomb County as part of their group would enhance that. We know that Shepka's not going to keep bringing attorneys forward to us. These are the attorneys he has put forward. I still feel I want him on the steering committee. We didn't vote to decline moving it forward to full board. We just didn't vote in committee. So I would like to vote before we go into Christmas vacation. We're ultimately going to be voting on yes or no, up or down on this firm, no matter what. So that's my opinion. I would like to vote before going into Christmas vacation so that they have a shot at being on the steering committee. And if they didn't get that, we would never know if it was because we weren't on board. Thank you.
Thank you, Commissioner. And, Commissioner Sauger.
I just got one question. Whatever law firm it is, I hope we don't read updates about what's going on in the newspaper. And if it's your firm or whatever other firm, you notify the chair and let the board know. Because I get tired of reading what we're going to approve in the paper. So you see my point.
We're going to send you so much information, you're going to tell us to stop sending it.
Okay. I'll give you my address.
Okay.
Thank you.
Thanks. And Commissioner Kleinfeld, on that note, a motion can be made at this point if
Mr.
anyone.
Chair?
Yes.
I'd like to make the motion.
Go ahead, Commissioner.
Unless Veronica, were you going to make the motion? Okay. I'd like to make a motion to authorize Sam Bernstein's law firm of Farmington Hills and Weitz and Luxenberg of New York to act as special counsel for the purpose of pursuing civil litigation on behalf of the county against various opioid narcotics distributors.
I'll support that.
Motion made by Lucido, supported by Brown. Any discussion on this matter?
Discussion on it.
There is hold on. I have a list here. I have Commissioner Kleinfeld. I'm sorry.
No, I didn't.
Oh, you didn't remove, so hurry up. You'll be first on. Okay. Go ahead, Commissioner Toko.
Thank you. I won't be able to support the motion, but it is no reflection on the Bernstein law firm. I am an attorney, and I am aware of your stellar reputation in the community. My no vote on it goes more to the process here and my role as checks and balances. And if our corporation counsel decided not to speak to any other firms, I can't just be a rubber stamp to say, well, I know corporation counsel won't do what we want them to do, so let's just vote yes. So my no vote is in no way a reflection on the ability that I think that you can do, but more on our process. Thank you.
Thank you. I don't have any other speakers, so I guess I'll speak. I agree with Commissioner Toko to a point. We get shut out of a lot of things around here that people aren't happy about. However, in this case, it's pretty crystal clear in the charter how this works, that the executive has a say in this because he is in charge of our corporation counsel. Our corporation counsel picks the firm that they believe is right. They come before us. This is how it happens every time that we have an outside counsel that Mr. Shapka comes before us. We don't ask him how many firms that they tell us, this is the firm that we've picked for this, they're an expert in this field, and we agree with him and we move on. So I don't remember, and correct me if I'm wrong, but I don't remember ever having the process be, well, bring us 3 or 4 more firms on this. Now, in other instances, in different situations, we have asked for different candidates or different things to be brought before us, but not in a situation where we actually have a request for outside counsel from our corporate counsel. So I will say that to change the process at this point doesn't seem like the right time to start changing that process. We have, I think there's 2 reasons that people will vote no, and one of them is what you mentioned, and quite honestly, we all agree with the degree that we get shut out of things in this county, and we're not happy about it. So we can vote on that and be sitting out on the outside of this with watching what's going on in this type of a suit, because we know, just like I forget which one of the commissioners said, that Mr. Shapka is not going to come to us at any point with someone new. It was probably this or nothing, and I can't speak to that, but because he has actually picked who he thinks based on everything that he's heard, and I believe he's probably met with these gentlemen several times. So, and then we have a group of people that I believe at least have spoke to me before about that we feel like this is grandstanding. And you might be right to a point. There is an element to this that might be grandstanding, and I'm going to speak to that for a second. There are many times that people grandstand, and if we were going to grandstand on the wrong side of an issue, I would be completely in your camp that, yeah, we're grandstanding. This is a bunch of BS, so to speak. If I'm going to grandstand about something, I'm going to grandstand about something that is this important and that has this type of an ability to put a dent in what's going on around here. We all know that no one single act is going to cause this problem to go away. There's been a bunch of different things going on, but we also know that there's a possibility we might get a little bit of money out of this to help this situation. I mean, we're the budgetary authority here. We get requests from the sheriff department, they need more people. We get requests from the prosecutor's office, they need more people. We just had the medical examiner come in to us. We have a limited amount of money to take care of these problems, and this is a big problem, and we all know it. This is an opportunity to possibly make some money, and it's not guaranteed, right? I don't think that, can you just give me an idea of how many communities you've signed on to this at this point? Can you put the microphone on, Mr.
Right now, conservatively, I would say it's about between 6 and 9. I think that may change to about 12 by the end of the night tonight.
Okay.
But we expect probably by the end of the month to have probably 20 counties.
Great.
And some cities as well.
That being said, we're certainly not going out on our own, forging a new path, hoping that this might work, without anybody else thinking that this is a good idea. So I'm going to say that on the grandstanding side of things, even if it is a grandstand and we don't make money off this, there's also the possibility, and we've talked about this before, injunctive relief. And injunctive relief might work just as well as us getting money. If we can stop what's been going on or change what's been going on, that is as important or more important to me than making $1 off of this, even though that would be a nice side effect of this. So, I'm going to go back to, well, why are we just suing this person and this group? I mean, the cigarette industry, every person that owned a store knew that cigarettes were bad for them, but we couldn't go after every store that sold cigarettes, just like we can't go after every doctor that prescribes opiates. That would be an impossible lawsuit. So when you look to a lawsuit, you look to the prime candidates that are, within a group that you can actually pin something to that's been going wrong. So I don't, to me, there's no issue with not going after the doctors or, any other people that are nurses that even prescribe this. I guess I just want to make a point. At this point, we are not responsible for any fees or costs. So this isn't something that we needed an RFP for anyway, which we don't get. We're not paying any money for this, correct?
Correct. We would advance the costs in this case. And with respect to some counties have asked about, and other potential clients have asked about, what are the potential sanctions if this went way off the tracks. Federal rules of civil procedure, which cover this, assign the sanctions, if there were to be any, to the attorneys that sign the pleadings, and that would be Paul and me, but mostly Paul. But in this particular case, when you have a case where the judicial panel of MDL, the JPMDL has established an MDL, 41 attorneys general have prosecuted these claims. The defendants have pled guilty and/or paid fines already in similar legal theories that will be used in this case. The likelihood of that is we're very comfortable with that. I can't say zero, of course. And given the nature of the judge to whom this has been assigned, the likelihood of that happening is we believe zero or very close to zero. And if it were to occur, it would land on us.
Great. And back to finally on the grandstanding side of things, and worrying about that, if we make $1 but we're on the right side, or if we don't make $1 but we're on the right side of an issue, we certainly will tend to look better in the public. And don't think for a second that this would not be something that would be publicly noticed, that we as a county decided that we don't want to pursue something that Oakland, Wayne, I believe Detroit might be on as far as one of the groups that you have.
Yeah.
All of the major metropolitan areas around us, including everywhere else, in the state, 'cause I know you were up in the middle of nowhere all this weekend, would be a part of. So my recommendation is to approve Commissioner Lucido's motion. Oh, yeah, I'm sorry.
Mr. Chair, just a quick
I have Commissioner
comment.
Majek on
Yeah,
this.
just a quick comment. I'm voting no also, just echoing what Commissioner Toko said. Basically, the process this late in timing, I would have liked to have heard from Mr. Brewer's law firm. His firm handled a case that went to the Supreme Court, has a lot of experience, and that's my reason for voting no. Nothing against the two individual law firms being represented here today. Thank you.
Very difficult to insult me.
Great.
Give me a chance, I could.
No, sorry. Seeing no other speakers, time to vote.
All right. It's like a game show.
Okay, motion passes 8-4. Thank you, gentlemen, for coming out and presenting.
Thank you so
and,
much.
I
We
appreciate
your
it.
time. Thank you.
Item number 10, appointments. We have 10A, Friend of the Court Citizens Advisory. There's 2 vacancies. Wendy Johnson, Perry Simmons. I believe they both came to speak last week. We need a motion to concur with the executive's recommendation. Made by Commissioner Brown, supported by Commissioner Toko. Please vote. Okay, motion passes. 10B, Brownfield Redevelopment Authority. 3 reappointments. David Skirdo actually contacted us and said that he could not make it. After 2 times trying to reach Dana Camphouse Peterson and Glenn Wynn, we've had no response from them as to whether they're still interested in this or not, and that was the last question we posed to them, if they were still interested in this position. We've emailed them twice on emails that were given on their site. So, do we have a motion to concur with this, or?
Mr. Chair.
Mr. Chair. Oh.
I think I heard Commissioner Romano first.
Thank you, Chair. This is executive reappointment with board concurrence, but if we've had contact with David Skirdo, and he said, yes, he'd like to be reappointed, I'd like to make that motion for him, and at the same time, if we've had response and send out or look for responses from Dana Camphouse Peterson and Glenn Wynn, and they did not respond, I will not make a motion to reappoint them.
Can we second it just so I can, well, the motion is, let me tell you, the motion that you're going to make is to appoint David Skirdo at this point?
Yes.
Okay. Do we have a second for that? Support by Commissioner Drollet, and then comments. Go ahead, I saw your hand first, although. Please get on the list.
As to Commissioner Romano's comment, if the executive put forth Dana Camphouse Peterson and Glenn Wynn, can't we assume that they sought reappointment? I mean, why are we double checking to see if they really wanted to be appointed?
Well, so I'll just, it's up to you. However, as a board, we can do whatever we want. We can rubber stamp anything that comes up for us, or we can at least have some comment from people that are asking for a position for us to vote on and giving us some kind of feedback. We did specifically ask if they were still interested in this with emails that they had communicated with us on at the beginning. So if we're worried about processes like we were in the last item, I think this is one of the processes that maybe the board might need to look at, that if we're going to be the rubber stamp, then we probably shouldn't even have these. We should just let the board chair sign off if there's only 3 that are getting reappointed to something like this. Otherwise, I think just the pure respect of an answer, I don't think we were asking for them to show up, is why this is where it is right now.
Well, so, that's my question. I mean, was there some indication that they may not be interested?
The fact that we hadn't heard from them at all about this meeting, about showing up for the meeting, about whether they were, whether they could or couldn't make the meeting. We always make an invitation to people. And I would say most of the time we hear about it. So, yeah.
You didn't get a response, am I correct, Chair?
Yeah, twice.
Thank you.
Yes. No. I mean, listen, it doesn't mean that we couldn't appoint these people again. Let's just say the vote goes no on the other 2. Doesn't mean that they couldn't be appointed again. This is just, at this point, the discussion is, do we appoint people that don't give the board the time of day to even answer a question if they're even interested in this, because they might have signed up, a month and a half ago when the opening became available. So
I mean, I guess that's my question, is because my understanding from what people have been told in the past is you're welcome to come if you want to, but you don't have to if you don't want to. And so if somebody says, okay, well, I was a commissioner, most of the commissioners are familiar with me, and I don't have to come if I don't want to, does that mean that she's ignoring us?
Commissioner Toko, your point is well taken. However, there was a second follow-up request to both of them to at least ask to make sure, circumstances change with people. I mean, I've signed up for something and next week couldn't do it or didn't want to do it. So we haven't heard anything that they don't want to do, but we haven't heard anything after request to say that they do want to do it. So, I mean, I guess that's where we come to right now. There's a motion. I mean, there's other people that want to speak on it, so.
Okay.
Commissioner Duje.
Thank you, Mr. Chairman. Basically, we're voting on a reappointment, that this is an executive appointment with both board concurrence. I will assume that the executive has talked to all 3 of those people and Diane McGee and everybody else that he puts on the list in front of us. And I agree with Commissioner Toko that we've said before, if you can make it, make it. If you can't, don't. And by the look of it, this has to be done by the end of December. And this is our last meeting of the year. It says 12/31/2020. That's when it expires. So I would imagine it expires 12/31/2017.
Commissioner, there's no expiration for current running serving members, so there was a whole long gap without even a request to reappoint anybody beyond their end of their time.
I understand that, but still, after everything's said and done, the executive gave us 3 people to reappoint and 1 person to reappoint to the Civil Service Commission. I think it's kind of mean to say, no, we don't want him, we want somebody to come before us, and so on and so forth.
What if they don't want reappointment?
Yeah, but I have to assume that the executive talked to him for reappointment.
Okay.
I have to assume that.
You know what happens when you assume?
I'm entitled to my opinion. Thank you.
Thank you, Commissioner. Commissioner Kleinfeld.
Thank you. I agree with that. We've been given recommendations from the county executive, and you know what I don't want to do is I don't want to say, well, we're not going to appoint these two because they didn't respond to us. And then a week later, well, okay, we're appointing them now. If we're going to have an argument with the county executive over something, that's fine. Let's have an argument. This isn't worth having an argument over. He's put the names forward. I don't see the benefit in sticking it to him on this issue. Listen, I have my fair share of arguments with him, but there's no reason for this one. And with regard to letting the chair do it, I believe it is executive appointment with board concur, not with board chair concur. So I just want to make sure we don't go down the road of the board chair doing things that the board itself is supposed to do. There's a second reason for that, though. I might just not be able to support somebody because I think they're doing something wrong. There's something about them that I just can't physically support them. So we do want to retain that. But in this case, it does come across a little bit holier than thou that we want them to come before us. That's different than no communication between the county executive and the board. I don't want to come across
So Commissioner,
petty.
Just to understand, we didn't ask that they come before us or not, or we won't vote on you, number one. And number two, how would we know if we have that feeling of not to reappoint someone if we don't even hear from them nor see them? So I'm just counteracting, you kind of said one thing that makes sense.
I came at you a little sideways. I'm sorry about that.
Commissioner Drollet.
But I don't see this as the argument to take on. Thank you.
Commissioner Drollet.
Thank you, Mr. Chair. Just a little bit to follow up on the most recent comments. You did not request that they come before us. You sent an email, is that what was involved? And you asked if they were interested, or what was the? So
the initial request when we get these is we would prefer that you come before the board. If you can't, so tell me exactly what it says, I'm sorry.
We encourage them to attend so that you guys have an opportunity to meet them and ask them any questions, to concur in the appointment. And we asked them to RSVP also.
Yes, we asked them to RSVP, and in the case that we had the next appointee talk to us, the last three appointees came in, we've just had no contact at all with repeated requests just to say, are you interested? I mean, the second one was, just let us know if you're still interested. So that's how that went.
I do believe, I believe everybody who spoke on this has made some valuable points, but it seems like if our only value that we have is concurrence, that's our power, so to speak, it is our only opportunity to ask those people questions and find out if they represent what we think is important in that particular position. And if they can't make it, I respect it. I certainly know Ms. Camphouse-Peterson. I know she's very well qualified. But it'd be nice of them to at least respond, in some manner. So if Commissioner Romano's motion passes, I think an appropriate motion after that would be to simply table the other two and then see if they at least can respond, whether or not they're interested or in some manner. The point of having concurrence is not, there's got to be some value to it, I hope. So, thank you.
Chair, I'd like to make an amendment. I'd like to amend the motion to add Dana Camphouse-Peterson and Glenn Wynn, and that'll be a separate vote, so it doesn't put anybody on the spot. We'll see if I have support.
To do what? I'm sorry, I missed.
I said it's a separate vote, therefore it doesn't put anybody on the spot. It allows for a separate vote for them, but it just puts them into the, it just settles it.
Okay. The first vote, so we're going to have two votes. The first vote will be what?
When you call a vote, you're calling a vote on the amendment first, and then on the original.
to add them to it. Correct.
Got it.
Yes.
All three say
So,
that.
Commissioner Romano. You're up to vote. I mean, you're up to talk.
I'm just gonna say exactly what Mr. Klein thought. Vote, you don't wanna, you wanna put all three at one time and vote on that. If that doesn't go, you wanna go individually, we'll vote on that. So now we're voting on all three being approved.
The amendment, the first vote is just on the two.
Whether or not we should add them.
To be added to the concurrence
The
of
first
yours.
vote is just on those two. If that vote passes, then.
Then we vote on all three.
Then the
Thank you, got it, let's do it.
Okay, well, we're not there yet. So,
There's a motion and support, call the question.
no.
Call the amendment.
So, Leon, Commissioner Drolet said it exactly how I think at least a few of us have been feeling, right? Do we have a role? I mean, is it, when we concur on something, is it automatic? Commissioner Kleinfeld said herself, well, sometimes we wouldn't vote for it because we might have a bad feeling or something. Maybe they can't answer any of the questions. We don't really know. Listen, I don't care how this vote goes. I mean, I would vote for Dana and Glenn if they called tomorrow and said, oh man, we didn't get this or whatever. I don't really care. The point is, do we have any kind of process? And maybe we don't do it here, but we change our rules. And that says that they have to, come into us. We change our policy. Because if they don't have to even respond to us, then it just furthers the belief on the 8th floor that we're here to do nothing except for this. That's my take on this. And I don't think we're asking a lot for anybody to come and speak before us, or at least to write or call or respond to our questions. But that's everybody's choice. We can vote. So let's vote unless, I'm sorry, I have Commissioner Sauger.
Yeah, listening to this, it's an executive appointment. If we doubt it, we don't vote. But there's many things we got to add to our laws right now that's going on. What you just said, if somebody didn't want it, it's executive recommended them, then there should be an order. If we're not contacted by these people, we're not going to vote them in. So what I guess I'm saying is we got to do a lot more changing in our bylaws than just this. Thank you.
I'll agree that this would be one of the things that, no matter how this goes, that I would look at as a policy change for next year. So that, and maybe to be fair, we make that policy change before we act on this point, even though I'm not happy about the fact that we didn't get that way. So anyway, go ahead, Commissioner Nobody. Commissioner No Speakers. All right, so let's vote on the amendment to add Ms. Peterson and Mr. Wen to Commissioner Romano's.
Because it's an amendment. Because what it says up there isn't actually.
Well, if you add them, you add 3 of them.
So the amendment should just be the 2.
You'll clean that.
Commissioner Lucido, can you send your vote?
You send your vote.
Something's wrong with the tablet.
Can you give me a verbal?
Hold on.
There you go.
Oh, there we go. Okay. It keeps closing out. Hang on.
All right. Motion passes. Oops, I'm sorry. Motion passes 8-4. So then we will go to the original motion of Commissioner Romano with the added 2 applicants of Dana Camphouse Peterson and Glenn Wynn. So this will be a vote to concur with all 3 of them. Okay, motion passes. So that is, no, it is not unanimous. 10 to 2.
Okay, it just showed up now. There's
Yep.
a little delay.
Sorry.
Thank you.
10C, 10C Civil Service Commission, 1-year vacancy, 6-year term, Diane McKee. There you go. To motion to concur, yes, moved by Duge, supported by Leonetti. Any discussion on this? Seeing none, please vote. She contacted us. Oh, I'm sorry. Save. Okay, passes unanimously. Item number 11, Government Operations Committee recommendations. Need a motion to adopt the 2018 meeting schedule. Moved by Brown, supported by Romano. Anybody? Please vote. Come on. There we go. Motion passes. We have a schedule for next year. So we have item number 12 with a whole list of
Motion to approve
well,
in their entirety.
and we'll carry the no votes forward. Will that work for you, commissioners? Okay, good. Then we'll make a motion by Commissioner Sauger, supported by Commissioner Duge, with the caveat that any no votes in committee will be moved forward. Please vote. Motion passes. Item number 13, the one-page change in the ordinance changing the comeback time from 3 years to 4 years. We discussed that ad nauseum the other day. That is the only change at this point. So I just wanted to clear that up, that those lined items were simply for just a notification that those were changed last time. So that is the one page that we got to see. I'm sorry, what? Do you have? Can I have a, well, I'll tell you what, we can speak on it in a second. Have a motion to adopt and a support, Leonetti, and then support by, can I get by Kleinfeld, Commissioner Kleinfeld?
Would you repeat what you just said?
Right, so this is strictly a motion that's in your, it should be in your packet if it's not. And it was the one page where where it was recommended to us to change from the 3-year comeback to the 4-year. They have up to 4 years to come back to get into the system. Yeah. Any other questions? Please vote. Item passes. I don't know by how much yet, but it passes unanimously. Item 14, proclamation. Would anyone like to take these in their entirety, or should we do them individually? All right, Commissioner Brown makes a motion for their entirety. Commissioner Kraft concurs.
Do we know that Jason Thomas wants to be Eagle Scout? He sent me an email.
I'll speak to it. Commissioner Drillette, I'll speak to it if you'd like me to.
People, it's Christmas.
Please vote. All right, motion passes. Board chair report. I just have a few things regarding Karen Spranger, our clerk. There was some questions asked. I'll tell you this. How about this? I have a whole list of all the questions that we asked that she was going to get back to us on. And to make this easy, she got back to us on none of them. So if anybody is individually interested in the questions we are waiting for her to get back to us on, I have them highlighted. Patty can get them to you. She does not have a candidate ready. Anything that she said, basically, she hadn't had going. She hadn't done the testing. There was no testing set up for the lien filers. However, I do understand that based on the mandamus action, that things are getting a little bit better over there as far as filings and liens go. I mean, you can just shake your head, yes. You can shake your head, yes. Yes or no? Is it getting better? Perfect. That being, you have a question, Commissioner? Yes.
Just a quick question. You know, the other part of that statute, I just want to bring that up, talks about a performance bond. Are we looking into that any further? It's a yes or no question.
At this point, we are not looking into it any farther. I mean, now I can't say that Scott's not still, looking into the possibilities of it, but so far it has been, as much as it sounds like a great idea, I don't know that anybody else outside of here has said, yeah, we think that you have a shot with this. So I won't say that it's a dead issue because they'll keep, the more people we ask, maybe we find out that there is an issue. I think we kind of got a performance bond going right now with the mandamus and everything that was placed in that from the judge in St. Clair. So I think that we're on the right track.
Okay, thank you.
So that's the end of the board chair's report.
Can we ask some questions to our Corporation Counsel on your report?
Oh, sure. Yeah, regarding her, if we want, yeah, that's fine. If you want to make everybody else crazy, that's fine.
Do you happen to know the status of the lien entries?
The numbers on the lien entries? I
Yes.
don't have the hard numbers. I know that 2 lien stations dedicated to lien entries have been set up, that starting from scratch, workspaces, computers, software. Lisa Emerson, who is the lien TAC, the terminal something, she's back on the job. She's been reinstated. She's engaged in training, and they've set it up, and they're chipping away at it.
So were you ever able to, or did you ever have the desire to check to see if the number that she provided to us was correct, almost 4,500?
That was the e-filing. I think it was 4,400. That was e-filing.
That was lien. She reported 2,200 on one and 2,300 on lien reports to the Secretary of State.
That was lien? I thought that was e-filing. Lisa Emerson was one of the witnesses who testified Monday on the injunction. And Lisa said at that point, this was as of close of business last Saturday, e-filings were down to 3,600 and lien entries were, and don't quote me on the number, but it was the low 2,000s, like 2,200, something like that.
Okay. And then has there been any determination on the information that she provided to us? We have been able to establish that a lot of it was just untrue. Is there anything that we can take action on doing that, about that?
For the untruth?
Yes.
Then, to call them
Like
what
to
they
have
are.
that discussion in closed session at some point.
Well, it's not pending litigation.
No, it's not pending litigation. I'll address it. What action can the board take? You could call her back to a further report. I don't think that's going to do very much. You're going to get the same dissembling answers that go nowhere. You could refer the matter to the prosecutor for possible addition to any contemplated perjury charges that he's furthering. I think that might be the more fruitful way of doing it.
So as a board, we would do it by resolution or just by letter to the prosecutor's office?
Just letter to prosecutor. I think that would be sufficient.
And do you know if that's something that they're looking into right now?
What she said in front of the board is not within the prosecutor's contemplation at this point.
Could her untruthfulness be added to the claims about the untruthful affidavit?
Sure.
That allegation?
Yes.
And who would do that?
If a prosecutor has multiple charges, they bring multiple charges.
Okay. Okay, thank you.
Sure.
Okay, any other comments on the board chair's report? Nope. Closing 15, going to 16. Anybody with new business? Just raise your hand at this point. My screen's locked up. No, it's locked up because I'm already have my vote to adjourn on it. Commissioner Toko.
Thank you. This Saturday at 10 o'clock at the Vintage House, Fred Miller and I will be hosting our 11th annual pancake breakfast. We collect food and financial donations for the Vietnam Veterans Chapter 154. It's been a great holiday party for the past 11 years, and I hope that you can join us. Thank you.
Thank you. It's a very nice event. I was there last year. If you guys can go, please show up. My kids were beating Santa Claus up all morning. New business. Anybody else? All right, seeing none. I have a great job this year with actually doing our legislative job as we should. And I appreciate all of your work. And just want to say have a Merry Christmas and a Happy New Year, and look forward to doing some more good next year. So that being said, public participation. Nobody in the public here to participate, so we're going to close that. Roll call, please check in. And meeting is adjourned. Anybody that's coming out with us, we are going to go down O'Halloran's, right down, which used to be Barleycorns, right next to Orleans, right down in Mount Clemens.